So Robert, what's special about your due diligence output?
Clients are not telepathic. When you are doing a deal, the lawyer is in it. And he knows what's happening or what's not happening from day to day. The client doesn't. He can get to the end of the week, he's about to go home on a Friday evening and the lawyer hasn't rung him. For all he knows, the deal has gone off, the agreement has been agreed, or nothing has happened. And so I always take the view that you have to keep the client informed, because it's part of my own doctrine that this is not just a legal matter, this is a commercial matter, and what the clients are interested in is the commercial side, what's been happening. To move on to your question, what I really like to see in the report, where we've been asked to do a full due diligence rather than a red flag operation, which Christopher may comment on in a moment, is that, again, this document is not just a legal document, it's a commercial document. It's a handbook. It's not to be put in the safe because the transaction has been closed. Good, we can forget about that one, all this legal stuff that the lawyers have been chucking at us. Our team is composed, as we've already said, of experienced lawyers. When they look at a series of agreements, as I say, the lights come on. They don't come on for junior lawyers because they look at a document and they look at the legal effect of it and they write it down. But for an experienced lawyer, he looks at the document, okay, he understands the legal implications of it. But more than that, if he's been in the business for a few years, he understands where it fits in to the company's business and the importance or non-importance to the company's business. So our report at the end of the day is intended to be a handbook. Whoever is responsible for administering the company, and this is where things can go awfully wrong in administration because nobody knows what's been happening in the target company before you go into it. It's not a document you put in the safe, it's a document, it's a working document. It'll have the legals in it, but it will also have, alongside the legal jargon, it will have the comments of a lawyer, the commercial reality or importance. Again, some agreements will have no particular commercial importance to the company, but most will have. And an experienced lawyer looking at this will say, yeah, okay, this is important. It isn't just enough for me to write down what the document says. I should write down what the implications are. And Christopher alluded some time back to what is an absolutely classic case, which are the contracts of the company. Right? And I pointed out that the contracts on the table are in a pro forma, and if you could just look at them and write and say they're in a pro forma. The really important point is, if they are customer contracts, how much of the business does each of these documents represent? Because, as I mentioned previously, if you've got a contract that's 50% of the company's business, you better tell your client that it is, because if he loses it, he's not going to be very amused. So that's where we go. This is a Bible for running the company. That's what we intend it should be. And I rather suspect that we are unique in this because too often junior lawyers are involved in doing this and they just don't have the experience. It's not fair on them. You need to give these documents to someone who understands the commercial implications. In a normal firm, it's going to cost you a lot more. With us, it isn't. Our team are self-employed lawyers. Their charge-out rate, to use a phrase you all understand, is pretty well equivalent to these grunts who are on 150,000 a year and whose charge-out rate is really now quite considerable.
This knowledge transfer from the investigating lawyers to the buyer's legal team for a post-transaction integration of the target. It is part of what we provide. And so we'll work out early on with the client at the beginning of the transaction, how much integration are you going to do of this organisation that you're buying afterwards? Are you going to leave it alone as a standalone organisation, in which case there might be limited integration? There'll still be matters that need to be remediated, but for instance, all of the legal contracts might not need to be transferred over. But if they are going to take it into their own organisation. Then what we will do during the transaction is that we'll organise them according to the buyer's document management system structure. And what they might be also interested during our exercise is providing the information that will enable them to then manage those contracts. So when are they coming up for renewal? And that will also help them with any rationalisation that they're going to be doing. So, for instance, we're not going to need all of these suppliers, but it may be that there's going to be a cost to terminating some of those supply contracts. So if they're relying on the fact they're going to save money from certain things that are contractually agreed with third parties, they better know early on whether or not they can do that without cost. So, for instance, if you're terminating an agent in Europe, there will often be compensation if you're terminating them early, and so on and so forth. We've mentioned the knowledge transfer for documents, both contracts and, for instance, company secretarial records. Then there's going to be the integration or the rationalisation that comes out quite typically of the governance. So do we need all of these companies? So there might be 2 companies now, post-transaction, in the same country, doing the same thing. They both might hold, for instance, a licence from a government, for instance, in the insurance sector. These things cost money to maintain, particularly for reporting purposes to regulators. They have to have their own insurances themselves and so on. So there's going to be this rationalisation exercise. Now, of course, if they then decide we're going to wind up one of those companies, all of the rights that that company has need to be assigned out to the company they're going to keep. Now, these sorts of exercises take a lot of analysis and a lot of legal work, which put a lot of burden on the acquirer's legal team. So quite often they'll say to the third-party lawyers, whether it's the negotiating lawyers or us, yes, we'd like you to support us in the integration, and because we have the knowledge of the target, that's something that we can certainly assist with. An important aspect is compliance. So with any due diligence, there are going to be issues, contractual, regulatory and otherwise. And in some of these areas, this can be posing quite a high liability potentially, such as data protection in Europe, where the fines can amount up to 10% of the groups, the acquiring groups' global turnover. Such things as data protection require a lot of very, very careful analysis from specialists. And if you've bought a company that hasn't done things properly, you'll need to remediate that pretty quickly. During the due diligence, you're assessing what sort of risk that poses and whether or not it can be remediated without there having to be any issues in the meantime, particularly dealing with any regulators. Other areas of compliance might include health and safety, employment, reviewing the real estate. For instance, there now might be 2 branches of the operation in the same town, or manufacturing operations that can be rationalised. That's quite often the case. You move all of the production out of one of the factories into another factory. That might have been one of the reasons you bought that company, in order to use their manufacturing or other operational capacity. Product liability, compliance, intellectual property. Now here's a big area of review. So are you going to be continuing with the trading names of the equity entity that you've purchased? Are they adequately protected? In the case of IT, if there were contractors or third parties otherwise who had worked on that IT to produce it, do you now need to make sure that there's documentation in place that assigns all the rights to you? These things might not have been able to be done by the vendor before the transaction. You've identified them through your information superiority. It may be that you've negotiated a reduction in the purchase price, assessed the risk and said, we'll deal with this afterwards. Intercompany arrangements. So if you've bought a group of companies, they will have their own intergroup arrangements. But now they've forming part of your group. So they need to fall under your intercompany arrangements. And this is all part of the typical rationalisation, that there might be one company in the group that provides the IT system that the rest of the group use and charges for it. So all of these arrangements need to be unwound in the old operation and redocumented in the new operations. There's a sort of tedious documentation and analysis that people like us can provide. Human resources, which could have been one of the first that I mentioned, the personnel in the target have come into the group. They're employed by the same company that they came over with. The acquiring group has its own contractual arrangements that it likes to have in place. So it's going to need to consider whether it negotiates with those employees that they will move on to new arrangements. And this can be a particularly sensitive area, of course. Often we've found that the company that's been purchased, the employees are on better terms. It might be they have more holiday. This can pretty quickly lead to dissatisfaction somewhere. So these things need to be considered early on and addressed early on in a very, very sensitive way. The insurances of the acquired group, there's no point in having insurances doubled up. So typically the acquiring company will have its group insurance covering all of its subsidiaries. So the new companies can fall under that. But that needs to be done. The group's taxation arrangements are going to need to move over. The policies and procedures that are operated by the acquiring group need to be instituted into the companies that they've bought. But also people need to be trained on it. They need to understand it. It may be that as part of that governance, the boards of directors will change. It may be that the personnel that have come over were on the boards of directors, but that may no longer be appropriate. So you get a lot of restructuring work going on, and this is the sort of thing that lawyers with our in-house experience can bring. This sort of thing can be agreed, in summary, with between us and the client who's buying a company at the setup stage of the original due diligence. Because if we know that they are looking to move in this way, then the preparation and the analysis that's being done during the due diligence process doesn't start afresh after the acquisition, should it go ahead. At least the prep work can be done where it's not costing a lot extra during the due diligence process, so that you're working as efficiently as possible.
Yeah, I just want to emphasize what Christopher just said, because actually this has a bearing on costs. You do need to mention this to the client at the beginning of the transaction, effectively to give him an option, because the client will not thank you if you do a lot of this work and present him with the kind of report that Christopher is talking about. He says, I don't really need that. You're not going to bill me for it, are you? And we have to say, well, of course we are, you know. And then, of course, you've damaged the relationship with the client. This is a lot of work, and it has to be done on the basis that the client knows from the outset that this is what you're doing. It's a useful process, but you need to tell him what it is. It all goes with my previous thoughts about the client is not telepathic.
Indeed.